and welcome back to another episode of 123 CMMC. My name is Dana Mantilia. I will be your host, and our guest today is Robert Metzger. Hello, Robert. How are you?
I am great. Thank you for having me.
I'm glad you're here. We're going to talk about a very important topic today, and it is civil fraud. What is it and how to avoid exposure?
Let's do it.
Yes. All right. So our first question is going to be, what is the new Cyber Civil Fraud Initiative? What is that? And who is that directed at?
Well, the Cyber Civil Fraud Initiative was announced by the Department of Justice last October with considerable fanfare. And, its overall purpose is to hold accountable entities who mislead the government, and in particular, those who might put U.S. information or information systems at risk. Over 100 plus years, the False Claims Act has proven to be a pretty effective weapon against contractor misconduct. But it's been used only lightly and relatively infrequently in the cyber area. So in October, DOJ said, we are now going to make a bigger deal out of this. We're going to assign more resources to it. They had a number of press conferences and programs where they were explaining all the things that they want to do with this initiative. But False Claims Act cases are actually kind of hard to bring, even if you're the government. And they're hard to bring and expensive if you are the lawyer for a whistleblower. And so, although this is a very serious issue, and companies should seek to avoid being exposed to the False Claims Act, some numbers are kind of relevant here. In 2021, the Department of Justice initiated 203 new actions under the False Claims Act. And relators, or counsel for whistleblower, initiated about 600. So that's a total of 900 cases. Those cover all of the industries where there's any form of federal contracting, including medical and healthcare, where most of the actions and recoveries have been. Now, DOJ has now dedicated some resources, and they've made it clear to the whistleblower bar that DOJ is looking for whistleblowers to bring cases that DOJ could pursue. So it's definitely something to take seriously, but the likelihood of an investigator knocking on the door to your company, is relatively low at present.
Well, those are really low numbers relative to everything, within the government. So I didn't realize that. Well, I do think that there's going to be a little bit more of a push on this with the, with CMMC and, everybody who's still can self-attestation. That it might, be some people out there that are like, no, we really aren't doing this, or, this company really isn't doing that. So, but it's interesting that it's so small. And I wonder when they say they've thrown additional resources at it, how much more they're talking about.
Well, I think they've added one or two lawyers, and they're being more receptive to cases that are brought to them by whistleblower counsel. I should mention that I do a lot of stuff in the cyber area now, but earlier in my career, I dedicated a sizable fraction of it to the defense of companies, large companies, who were accused by the Department of Justice, typically under the False Claims Act. The cases I handled, involved defective quality or misrepresentation of costs and charges, or substitution of a non-compliant product for the one that was expected. I spent probably close to a decade doing this stuff in real life, and I can tell you for sure that no company with any sense wants to take any chance to find itself exposed to an action under the False Claims Act.
Yeah.
Even if it isn't meritorious, the process of responding, investigating, defending, and potentially going to trial is extremely expensive and highly disruptive. And so even though the number of cases that are brought, may be small, still important to take the risk seriously. In part because there'll be some cases that might be brought by a whistleblower or investigated by an inspector general, where you will decide once you're confronted with the allegations that you're going to settle them rather than let these things become publicly filed and come out from under seal. Often whistleblower cases are filed under seal while the Justice Department considers whether to take on the case in its own name. So, one of the questions you had mentioned to me, Dana, was who is this directed at? And if you look closely at what the Department of Justice has said, there are some kind of interesting distinctions. The first two categories are a little different than what you might anticipate. The first one is companies who sell cyber products and services to the government. And the second is companies who maintain data on government systems and a third is cloud service providers. Here, the government wants to make sure that those that it pays to perform cyber for the government, or those whom it pays to and it entrusts with the security of government data, including cloud, that they do their job properly and without any misconduct, misdeed, or fraudulent. But they go on to say that there are two other categories of companies who this is directed at. One is companies who violate cyber rules, regulations, or contract terms. Well, conceptually, that is the entire defense industrial base. That is anybody who receives the DFARS clause 252.204.7012 and who has controlled unclassified information. So there's at least a theoretical exposure there. And they further say that companies who fail to timely report cyber breaches are also exposed. Now, all these things get a little complicated because those requirements are, important, and the government has many good reasons to want you to comply. But, the reporting obligation creates exposure only if you violate an actual requirement. And a lot of companies who are in the commercial world are being encouraged to report quickly, but there's no present contract or legal requirement to do so. For defense contractors, there is in that 7012 clause.
Wow, that was very, very helpful. You have a lot of experience with this. All right, so our next question is, are government contractors exposed to civil cyber fraud claims?
Definitely. There is one very notable case that's actually going to trial on April 26th. This is the case of Marcus versus Aerojet Rocketdyne. Mr. Marcus was a leading cyber official for Aerojet. He was critical of Aerojet's conduct and wrote several internal reports and recommendations which were disregarded by management, he alleges. And he was then fired from Aerojet. Well, he brought his case to the attention of the Justice Department. The case was actually filed under seal way back in October 29, 2015, long time ago. These cases take a long time. And, he essentially said that Aerojet had misrepresented its cyber status to the government and that it was material to the government's decision to contract with Aerojet, that it had good cybersecurity. And he said that Aerojet wasn't providing adequate security in light of what it actually knew of its cyber deficiencies versus what it disclosed. The case has been defended by the prominent litigation law firm of Kirkland & Ellis, or the litigation part of Kirkland & Ellis. I was a partner at Kirkland & Ellis. I did False Claims Act cases against defense contractors. They are really one of the very best. They're also extraordinarily expensive. Well, about 6.5 years have passed, and the case is now set for trial on April 26th. Kirkland & Ellis tried incredibly hard to dismiss every claim and contention that was brought by Mr. Marcus. And then when they couldn't get them dismissed at the outset, they tried to show that the evidence was sufficient for summary judgment, meaning that there could be no dispute as to any of the material facts. And the reason, of course, is that Aerojet did not want to go to trial before a jury on these complicated issues. Well, for the most part, that defense has lost. This case is going to trial on most of those issues. And it shows for sure that a defense contractor can be subject to a civil cyber fraud case. And there are some others. There was one that was settled by Cisco, and I believe there was one that was settled by IBM. So it can happen. Now, interestingly, in the Aerojet case, it is the sort of classic recipe of uncertain law and very bad facts. There are a lot of kind of interesting legal defenses, but it's a little hard to win with these, intellectually attractive legal defenses if the facts appear to be terrible. And, the allegations, whether they're proven or not, by Mr. Marcus about what Aerojet knew as opposed to disclosed, and did as opposed to didn't do, and lost in actual information that was, exfiltrated. I mean, those allegations are pretty bad. And that puts, Aerojet in a tough position of looking at going to trial in, a little over a month, or actually, just a little over a month, on some issues where juries might not be especially sympathetic.
Yeah, wow. That is going to be very interesting because obviously I'm sure the language is going to be very complex, and you have a jury of regular people. So explaining it's got to be kind of like if it was a medical malpractice and they're using all medical terms, trying to explain this to people that don't know the language. And I think they're going to be more sympathetic with Mr. Marcus than they are with the company. So
right. And the actual allegations about cyber compliance and the minutiae of what you did or didn't do and this or that control, they get pretty complicated. But the way that the Marcus litigation teams put this together is to say, for example, you got a report from a consultant that you had all of these defects. A consultant did a penetration test and recommended immediate action. You did not disclose that report to the government. You were selective in what you shared to the government. You did not do the pen test and you did not tell the government. And they said that there was evidence of 4 actual breaches where allegedly huge volumes of information were stolen from the breach. And they alleged that that was not disclosed to the government. Moreover, Aerojet has said, well, one of our defenses is that the government knew that we were not completely compliant, and therefore it continued to do business with us anyway. Well, the plaintiff's counsel has said, well, the government only knew what you told them, and you didn't tell them enough, and what you told them was a misrepresentation because it was selective. They also said, the plaintiff made a big argument that, well, I mean, this really doesn't matter, first, because nobody gets it right, and second, because you knew we had some cyber issues and you continued to buy missiles from us anyway. Well, as a matter of law, those defenses were rejected just a couple of weeks ago. And essentially, the judges said that it's for the jury to decide whether the government would have continued to do business with you. It's for the jury to decide whether you provided adequate security. Remember that phrase from 7012. And it's for the jury to decide whether you had a culpable state of mind in knowing that these breaches occurred, but not informing the government of them. So it's kind of a big petri dish for some of the issues that we've described earlier.
Wow, they should do pay-per-view for this. I'm sure there'll be a lot of people that would like to tune in and watch. This is going to be very interesting.
I will volunteer a personal prediction that
they'll settle.
I would be surprised if this doesn't settle before trial because I've read some of the pleadings and it looks, I could be wrong, and Kirkland may have a spectacular defense. Who knows? Mm-hmm. But it looks a little hazardous. And I can tell you from experience that going to a jury trial in highly technical subject matters is a bit of a lottery, too much of a lottery.
Mm-hmm. Mm-hmm. Just like when they first started talking about DNA with the O.J. Simpson, the jury didn't understand DNA too much, so they kind of lost him on that. So, okay. So, will these claims be brought by the government or by the whistleblower? That's a good question.
Yes. So, the way the statute works is that the government can bring claims in its own name, and sometimes before it does so, it will start with an investigation. The government's made available to the defense contractors a hotline number where if you're a whistleblower, you can call one general number and somebody typically from an inspector general's office will proceed. If the government investigates you before they file a false claims action, you're going to know it and you're going to get some chance to show them that all is good and that they shouldn't be upset. But oftentimes the cases will initiate when an insider, a current or former employee, who's disgruntled or takes exception to what you do, they will essentially decide that they're going to compile a case. And if they are the first source that informs the government of a potential violation of the False Claims Act case, then they can bring the case in their own name. They can bring the case in the name of the government. And such cases are originally filed under seal with the court so that they're lodged and they're with a court that has jurisdiction, while the government then proceeds to decide whether it wants to intervene and take over the case. The whistleblower counsel always wants the Justice Department to take over the case. When they do, that means that the whistleblower counsel can sit back and watch while DOJ does all the work. Their share of the bounty, if the case succeeds, is a little lower than if they do it themselves. But a significant number of cases brought by whistleblowers do proceed even if justice doesn't intervene. Marcus is such a case. Mm-hmm. And I looked it up, and there were some statistics that said that in 2021, the Department of Justice staffed 25% of new False Claims Act matters that were filed in district court, meaning the other 75% were being pursued by whistleblowers. Now here, the government has made it very clear in the Civil Cyber Fraud Initiative that it wants the participation of whistleblowers. There are 3 reasons. 2 of them are typical of False Claims Act cases. They need the knowledge of an insider who can bring the alleged wrongdoing to them. Second, they need the documentation, the evidence that the insider may have, which could be extremely difficult, if not impossible to get, if you were not working at the company. Evidence matters enormously, and evidence are things that are documented, reports, emails, memoranda, things that you remember and allege later, in oral testimony, not so important. So they want inside knowledge and they want documentation, and especially in the cyber area, and this they have said, they want technical expertise. Why? Well, it's just as you've mentioned, Dana. These are hard subjects to understand. And there are not that many lawyers at DOJ, I say respectfully, who do understand it.
Mm-hmm.
And so it's just crucial for them to get insiders who actually know what this stuff means and what you're supposed to do and whether it has a consequence.
That's a good point. I didn't really think about that, but you're right. You specifically, I'm sure you're very well versed with this stuff, but that's something, if you don't understand it, an insider is probably no other way if you don't have an insider. So that was a good point.
I mean, let's think about it. I mean, the kind of simplest false claim is when you build the government for doing something that you didn't do. And another simple version is when you build the government for something that you say meets certain performance specifications and you know that it didn't.
Mm-hmm.
Well, these really are not those kinds of claims. I mean, the government's theory here has to be that you told me by taking a contract with that cyber clause that you were going to have adequate security and that you were going to follow NIST 800-171. You told me that, and in reliance upon that representation, I decided to do business with you. And I might not have given you that contract if I had known that you never intended to or were willfully disregarding your cyber obligations. So the government's theory is sometimes called promissory estoppel. In other words, you promised me impliedly that you were going to comply with cyber requirements and you knowingly did not. You are stopped from denying the promise, and I can hold you responsible. Essentially, the government's theory is I would never have entered into a contract with you if I had known the truth about your cyber performance. And even if I can't prove damages, I'm still entitled to seek a fine of between, I think, $11,000 and $33,000 for every invoice that you submitted on the contract that you might not have received, but for the fraud.
Wow. Well, and what the thing is too, is that most people are already being held responsible to 800-171. And now those same people, a lot of them are saying, oh, we're not going to focus on CMMC until, really finalized and everything is all spelled out and everything, where if something happened to them tomorrow in this situation, they would be held responsible. And the government could easily say, you told us you were doing this and you weren't. So
look, timing is everything. This DOJ announcement came out, right around the time that CMMC 2.0 was announced. And it also came around, a few months after the president's executive order 14028, which emphasized the importance of cybersecurity. Well, look, I mean, CMMC 2.0 has high aspirations, and it's obviously got a lot of us paying it a lot of attention. But it produces an interval of a year, maybe two, between the announcement of 2.0 and the actual implementation of it through regulations and contract clauses. The government does not want to give everybody that furnishes its cyber services or everybody that sells to the Department of Defense, they don't want to give them a free pass. And so one of the tools that the government has, speaking of G government, big government, one of the tools they have is to kind of turn up the gain on enforcement. And this is, part of the purpose of this is to make people comply with the DFAR type requirements. If there are not regulations in place and you do not now have to have an assessment, the government recognizes that there are certain representations you make taking any contract with 7012, and the government knows that if you put information into SPRS about your score, well, I mean, you're making a representation to the government. So we'll see examples of where the DOJ whistleblowers are trying to make something out of what contractors said, which were different, worse than what they knew. Let's also recognize that it's been 5+ months since this new initiative was announced. Have we seen any giant new filings? No. What does that mean? Well, I mean, typically these cases take quite a long time to investigate. Recall that this Marcus case, which has very strong evidence, was filed in 2015 and it's going to trial, in April 2022. So the government will they're going to look for cases. They're going to want cases against bigger and medium-sized companies, probably not smaller companies for a variety of reasons, but maybe. They're going to want cases that kind of take different forms of violation and then make a case out of it so that they can cite those, essentially as public examples of why no one would want to get close to such exposure. Well, I mean, they're right. You don't want to get close to such exposure.
Vulnerabilities remediated. Businesses today face a number of cybersecurity challenges, from compliance requirements and third-party risk to skilled resource shortages, ransomware, and alert fatigue. At Vulnera, we recognize these challenges and offer solutions to do the heavy lifting. Vulnera empowers organizations with security solutions that perform continuous asset discovery, vulnerability assessments, and remediation validation in a single pane of glass, so your team can focus precious time on what matters: remediation. Vulnera.com. Vulnerabilities remediated.
That's for sure. All right, so I'm going to jump around here for a minute here. So speaking of Spur scores, so can there be liability from misleading scores posted to Spurs? Because you can't plead, well, I thought we were doing that.
Well, yes. I mean, it does increase the exposure. Look, a false claim essentially means that there's got to be something that you tell the government that you did or you're going to do, or something where you describe to the government what you are, where you know that not to be the case. We have to appreciate that just, simple error isn't enough to expose you, or, negligence where you made a mistake, not enough. You've got to have at least, reckless disregard for the truth. You have to, it could be, willful blindness. In other words, you just choose not to know those things that you clearly should have known. Or it could be, deliberate intent or deliberate intent to deceive. So you got to have intent. And you also have to have it be material to the government's contracting decision. Well, let's take a look at SPRS. So there the government says that I want you to do a self-assessment using the methodology that I've provided you, and I want you to post the score along with when you think you're going to close it. Well, I would expect that there is a sizable number of companies who have erred on the side of reporting scores better than they had, and a sizable number of companies who are not making quite the progress that you might expect if you were to read those dates for when gaps will be closed. Now, those could create exposure because, there may be a whistleblower, an unhappy employee, or, an employee of high purpose and, morals who just says, your score is minus 160 and you put in a score of 80 and I can't tolerate that. So a case could result, but then we have to think about, does the government want to bring that case? Does a whistleblower counsel want to invest in it? Because maybe years before that whistleblower counsel gets paid anything. And so here we got a couple of issues. First, you have to prove a knowing violation. And unless the inside whistleblower knows that your actual self-assessment score was minus 100 and knows that you reported a score of plus 100, well, just a mere disagreement as to whether the score was right or wrong may not get you past that level of knowing intent that's required. You also have to show, the government may want to see if there's any damages there. In a smaller or mid-sized company that has a small number of contracts, if there are not any damages, then you could be bringing this complex case only to find out you've got 10 penalties worth $33,000 apiece. You might do it, but you might decide that your resources, whether as a whistleblower counsel or as DOJ, are better spent on bigger cases with bigger results. And then there's this issue of materiality. This one's going to be kind of important on SPRS. Just exactly what does the government do with those scores? We know they're there, and we know they're available to contracting officers in considering the responsibility of a company. But if I were to put on my, litigator hat for a moment, and somebody were to threaten an SPRS case, I would say, well, tell me exactly whether anyone actually looked at my SPRS score. If that score was posted And it was never considered by any contracting officer or anyone else in deciding whether to contract with me or continue to do business with me. If the first time that you, government, looked at that score was after some whistleblower reported to you that it was wrong, what's the materiality? I mean, nothing in that score, actually would have influenced your behavior, whether to do business with me or continue to do business with me. So I might say it's not material, even if it's false.
Mm-hmm.
Now, just illustrating the wheels within wheels here, the government's answer is, it doesn't matter that we looked at the score or not. What matters is that you posted it. If you had refused to post it, then we might not have done business with you. The fact that you did post it means that we have a right to assume that you are complying with that 7019 regulation that requires that you post it. So, what is my net effect here? I think there are going to be fewer SPRS cases than you might think, even though there's a lot of suspicion of, misleading SPRS results.
Mm-hmm.
But, if I were DOJ, I'd probably look for a couple, just to make the point. And really, that's how these things are done. They can't, there's 80,000 companies who are going to be subject to CMMC level 2. Do you think that they could pursue even, 500 civil cyber fraud cases in a year? No way.
Mm-hmm.
Could they pursue 50? Maybe. But, if they're only going to pursue 20, they're going to want to be pretty sure that they get some sort of popular result that's going to affect behavior of many, even if the case is only brought against one.
Boy, oh boy. All right, we're going to jump over here to what's the liability of companies if their cyber practices are found to violate the False Claims Act? We kind of talked about this a little bit, but I want to get into a little bit more.
Well, it's really important because the False Claims Act, is not a gentle gesture, right? It's an in terrorem instrument. Believe me, I know. I've defended them. I've defended some that are brought by DOJ with a combined civil and criminal investigation with grand juries and search warrants. I can promise you for sure that anybody who has ever been through one of these things will be, bending over backwards several times on a regular basis to avoid finding themselves exposed again. It is a terrible experience, and it is unbelievably expensive and disruptive. So, the liability can be extremely large if there are damages to the government, because the biggest financial liability to a company would be that the government can collect treble damages from a false claim that it proved. So if you are, a pharmaceutical company and the government spends $100 million buying, let's say the government spends $500 million buying opioids from you that, you knew it didn't need for medical practitioners who did not have the adequate justification. Well, the government could then say, I spent $500 million on these false claims for unnecessary products, and I treble that. You owe me $1.5 billion. Well, that's kind of what has happened, in fact, in the pharmaceutical industry relating to, OxyContin and I think Purdue Pharma. So, in the case of cyber, though, doesn't it get a little more complicated? Exactly what are the damages? I mean, you could say to yourself, well, if there's a big exfiltration of data, well, that surely causes an injury to the government, and that injury maybe could be trebled. But what is that injury? The fact that information is exfiltrated, however terrible that is, doesn't mean that anyone has actually made any use of it. Or if they did make use of it, it doesn't mean you have any way of knowing what that is. Or even if you suspect what it is, such as the Chinese, emulating a U.S. system, it's going to be pretty hard to, attach a monetary amount to. It's going to be hard to attach a monetary amount to the damages. So one of the things that I think is held back, the bringing these cases, to an extent, is the uncertainty of monetary damages. But there is more. As I mentioned earlier, if the government uses this promissory fraud theory, as the whistleblower in Marcus is using, its essential argument, is that every single contract you got from a period of years where you had this clause, which you knowingly failed to fulfill. And I want to emphasize, it's not just that they missed some controls. One of the central allegations in Marcus is that the DFARS clause there applicable required adequate security in a dynamic environment, and that the evidence of bad security was sufficient that a jury could find that the security wasn't adequate. This doesn't go to whether you met, NIST SB 800-171, control 3.1.2. This is something where the jury could say, I'm going to look at the overall adequacy of your security. And if you are, porous, brittle, get hostile consultant reports, information is taken from you, if you mislead the government on real security versus what you knew, it was worse. Well, again, do you really want to go to jury with that kind of exposure? I don't know. So, what the argument there is to say that, well, okay, maybe I can't collect in trouble damages, but I can impose fines for false claims between $11,665 and $23,331. Well, if you're a big company and you got 1,000 claims for payment on those contracts, do the math. It gets to be big numbers. Moreover, companies that want to continue to do business in government contracting are not going to like the consequences of a False Claims Act verdict against them, because that's going to impair their ability to get certain types of work. Also, we should recognize that, and finally, the whistleblower gets a piece of this. And, the range for the whistleblower is between 15 and 30% of the recovery. Well, the recovery's got to be pretty big in Marcus. They've been after this case, since October 2015, private counsel only, against one of the biggest and most, competent law firms in the world. And, you can assume that the Marcus firm is not doing this just solely in the public interest. It's figuring that it, might be able to get, if it gets $100 million in damages on fines, it might get 30% of that. $30 million, pretty good return on investment. Let's also not forget that, the measure of judgment is also subject to the imputation of interest from the point in time of the misconduct. So the numbers can add up. Don't want to go there.
Wow. Well, this was really, really good. What a great, great episode. We'll definitely have to have you back to talk about some more of this stuff, and then keep us posted on that lawsuit, the April lawsuit. So that'll be interesting to see how that finally winds up turning out. So
Yes.
Thank you for your time.
Thank you.
And thank everybody for watching, and we will see you soon on the next episode.